The following interview is a presentation of Ofiɔ Media. It first aired on KXLU Los Angeles. My guest today is Kathleen Kim, an expert in immigration law who teaches at LMU Loyola Law School in Los Angeles, California, where she also serves as the Associate Dean of Diversity, Equity, and Inclusion, and where she co-founded the nationally renowned Loyola Immigrant Justice Clinic, as well as the Loyola Anti-Racism Center. She also founded the Rights and Systems Enforced Clinic, or RISE Clinic at Loyola, the first law school clinic in the U.S. that represents survivors of violence caught up in the criminal justice system through trauma-informed lawyering and with the goal of achieving anti-carceral justice. She's the lead editor of a forthcoming book on immigration that will be published as part of Cambridge University Press's Feminist Judgments series, and in other forthcoming pieces, she adds to the emerging theoretical framework that's being called critical immigration theory by expanding on her earlier groundbreaking work that addressed the rights of trafficked people. Her past accolades include having served as a Los Angeles Police Commissioner from 2013 to 2016, authoring the leading practice guide for civil attorneys representing trafficked individuals in the U.S., and as a Skadden Fellow freshly out of law school, founding the U.S.'s first legal services project focused on the civil rights of trafficked people. Kathleen Kim also has led a noteworthy life outside the legal sphere. Among other pursuits, she's a musician who performs with a number of ensembles, and she's a co-founder of the beloved music venue and art gallery Human Resources, a major hub of the Los Angeles art scene for over a decade. So Kathleen Kim, welcome to the program. Thank you so much for being with us.
Thank you. That was a really generous and flattering introduction. I don't think I'll ever experience that kind of introduction, so thank you for having me.
So happy to have you here, and frankly honored that you cut some time out of your schedule to make yourself available for this interview. Before we start talking about your own work and the work of your peers, for example, in this volume that you've edited that's coming out somewhat soon, I want to just cover some basic immigration law topics. So I'm just going to package up a few questions and pretend they're one question and kick it over to you. How has national security historically been instrumentalized for the purpose of restricting immigration? And how does this relate to what's called the plenary power doctrine? And in fact, what is the plenary power doctrine? And finally, how does the historical mobilization of national security concerns as a vehicle for restricting immigration relate to current restrictions on immigration in terms of both explicit arguments around national security and in terms of subtler, if not actually subtle, arguments about the good of the country or the well-being of the country?
Great. Thanks. Good questions to ask in sequence because they're all related, and the relationship between our government's treatment of national security issues is fundamental to the founding of the plenary power in our historical legal doctrine, and primarily within the Supreme Court, and the Supreme Court's very first holdings on the government's authority over immigration matters. And so if you don't mind the long-winded answer.
Please, no, go for it.
I'll start then with that history, which begins, the beginning of the story of immigration, the immigration regime we have today, and how and why it's largely a government tool to exclude non-citizens, particularly non-citizens of color, to curate a population in the U.S. that is majority white, Western European. All of that arose out of the abolition of slavery and during the Reconstruction era. So in 1865, when the Civil War had officially ended and the 13th Amendment, which abolished slavery and antebellum chattel slavery across the nation, was ratified, there were millions of African slaves that had been newly freed, and the other Reconstruction amendments, the 14th and 15th Amendment, also gave them political power. And within a matter of just a few years, 15% of seats across the states and the nation of seats in legislatures were occupied by black lawmakers. And that percentage, 15%, has never been achieved again. So Reconstruction was actually an incredibly important moment for the advancement of civil rights and an opportunity for the United States to, it's been called the second founding by historians like Eric Foner, who studies Reconstruction, and because it was an opportunity for the U.S. to dismantle the racial caste system that it had created through slavery, and those Reconstruction amendments were meant to achieve structural equality and achieve a multiracial democracy. But the entrenched systems of white supremacy and power that that ran way deeper than perhaps anyone imagined, except for those who retained that power, made it so Reconstruction survived for not even 12 years. And, and at the end of Reconstruction, and which was the literal withdrawal of federal troops from southern states who had been enforcing Reconstruction in southern states, that's when our first immigration restrictions were passed. And so this is 10 years after Reconstruction began, 1875. So the first federal law to restrict immigration on pure race, the intersection of race and gender lines was the Page Act, which prohibited the entry of Chinese and Asian women based on the presumption that they were prostitutes, and then Chinese men based on the presumption that they were coolies, which was the term used for indentured servants. So under this guise of paternalism or protectionism, that's when the first immigration law was passed from Congress. And when it came under constitutional review by the Supreme Court, in evaluating it, declared that the political branches of the federal government, meaning the executive branch and the Congress, had ultimate authority over all immigration matters in order to protect this country's borders, the United States borders, against threats to national security. And so that is the primary justification that the Supreme Court used, and then subsequently used time and time again, even to the most recent cases, for why the political branches of the government have exclusive authority over immigration matters, and thereby can exclude non-citizens even on the base of discrimination, based on discrimination that it would be facially invalid in non-immigration contexts. So the federal government can prohibit the entry of or deport non-citizens who are Muslim, or an extension of the logic of these early Supreme Court holdings also supported Japanese internment, even though Japanese internment interned many Japanese American citizens. But so national security as a reason, as a justification, was weaponized to control the population and makeup of the United States, and it's continued to prove to be a really effective tool for the government.
That's a great answer. To go a little bit off script, I mean, when you're talking about this kind of paternalistic excuse to exclude Chinese men, kind of on the basis of like, well, we don't want them to be exploited, so we're not going to let them in. I feel like there's just a little bit of historical resonance with some reading that I was doing a little more than a year ago, maybe, about when the British really formally colonized Nigeria. Part of the process of selling that exploitative effort at home, meaning in the UK, was to say that, you know, we've been trying to stamp out the slave trade in Nigeria, but Nigerians don't want to listen, and so we need to go over and take control so that we can shift their economy over to one of agricultural production. And obviously, you know, the colonial takeover was maybe the single most damaging event to that part of the world, that now country of Nigeria. But it was done under the guise, again, of paternalistically kind of saying that, yeah, we have to protect these people from themselves or something.
Yes, yeah, exactly. And I think that throughout the history of U.S. laws, and we can see both paternalism and a narrative that our country should be, the government of our country should protect it against foreign invasions, foreign threats, and those really are our two themes that have persisted, I think, especially, I mean, the immigration context have persisted from the origins of our first immigration restrictions. There weren't, you know, we were a borderless country before 1875, it's interesting how these contradictions in rhetoric can continue to exist without scrutiny.
Yeah, no, it is kind of incredible.
Yeah.
And yeah, hopefully maybe by doing these kinds of media appearances, you can move the needle a little bit.
Yeah.
You know, with your immense body of knowledge. I want to sort of shift us to the present now.
Mm-hmm.
In her book, Coerced,
Mm-hmm.
Work Under the Threat of Punishment, Erin Hatton talks about so-called privileged workers, which could be like, you know, let's say a college athlete or
Mm-hmm.
a grad student, someone who is basically told that, you know, you're lucky to be in this position, and if you perform well here, you'll be propelled to greater heights. Therefore, you know, you should work for what's maybe below the market rate for the labor that you're putting in. And then also talks about so-called immoral workers, the kind of the quintessential example, I guess, being labor from incarcerated people, where it's like basically our criminal justice system has found that you committed a criminal act and therefore you're a bad person and you basically deserve to work under these, you know, arguably very exploitative conditions for well below minimum wage in many cases.
Mm-hmm.
And Hatton groups these kinds of working conditions under the umbrella of what she calls status coercion,
Mm-hmm.
Which is a concept that you apply in a forthcoming journal article that you were kind enough to share with me,
Mm-hmm.
to undocumented workers and trafficked workers.
Mm-hmm.
I wonder if you could talk about how undocumented and trafficked workers are subjected to status coercion, and if you don't mind, please ground your description in concrete examples. Sure. And finally, if you can also just tie into that response, how U.S. government policy is kind of complicit in enabling this type of coercion, including via the Immigration Reform and Control Act of 1986 that I believe you also mentioned in that piece.
Mm-hmm. Great. Great question, Adam. You really did your homework. So Erin Hatton's book is fascinating. She's a sociologist, and so one among I guess a group of us that study coercion, and particularly in the workplace, because work is so fundamental to what we do, and I mean in our human existence. And in the U.S., work as a focus of examination is even more illuminating because of all the different kinds of power dynamics that take place. So, you know, at the most abstract level, we might characterize all of our, you know, our entire sort of economic system, economic society in the U.S. as one characterized by racial capitalism, you know, and so that is, but that's very abstracted out. So, along those lines, to fill that out more, poor people of color are constrained in the workplace, if they have even the opportunity to find sort of a low-income job, because if they don't comply with what might be egregious and substandard working conditions, they're constrained because they probably won't have many other choices for employment. And
they're probably, sorry to interrupt, but
yeah.
maybe considered like highly replaceable by their employers in many cases.
Absolutely, yeah, totally, yeah. They're considered disposable and you know, like transient, basically, yeah. And you know, those kinds of jobs require human contribution, human value, but the jobs themselves are not given this, you know, the status or the privilege of those jobs that you know, would require like formal qualifications on paper. And so the interesting thing about Hatton's book is she pays attention to, as you said, forced prison labor, which I think has a lot of shared themes and power dynamics that exist with undocumented individuals in their workplaces and trafficked workers. But she also includes individuals who are perceived to be privileged, and that can almost be a kind of more insidious type of coercion, because perceived as privileged, then one can't ever claim to be a victim, and one can't even understand what being a victim might be. And so it's very hard to assert oneself under a supervisor, employer, you know, faculty member, chair of the department, or whatever that a PhD student is providing value labor in, because they're not supposed to complain because they have the prestige of this. But actually a lot is being, she highlights that a lot is being extracted from them. So so she wraps that all up in this concept called status coercion. So I've written a lot about coercion too, and the way that I've defined, or the terms that I've used to define coercion, there are three terms that I've used. So in the context of human trafficking, I coined the term situational coercion, and that had, I mean, that sort of is a concept that I distilled from actual trafficking cases. You know, so a mix of and cases, you know, where, you know, that in which I was the attorney, you know, and I, you know, had I thought, a very like deep understanding of the coercive power dynamics that my clients experience, and which I thought was a mix of these two other types of coercion that that I've referred to as structural coercion and specific coercion. And I think Aaron Hatton's concept of status coercion encapsulates all three, you know? So, but with situational coercion in the human trafficking context, I'll give an example. A case, a trafficked domestic worker from Kenya, and she came to the U.S. With her employer, whose country of origin was Kenya, and the worker, my client, she is an economic migrant. She wanted to enjoy the promises of the job that her employer described to her. Like, you're going to make way more money than you make here. My client had a daughter back in Kenya, and the employer also said, I'm going to help you get a green card. You'll be able to bring your daughter. So that was just, you know, too good to refuse. And but as soon as they arrived, I mean, it sounds cliche, but it really does happen in like every trafficking case. Her passport was confiscated, and my client said it best when she literally said, I thought I was in the land of the free, but I became a prisoner, you know, which was indeed the case. So she was working 18 hours a day. She was also a nanny to her employer's kid, so it was really 24 hours on the clock. And her trafficker, you know, it's interesting because there is like just a level of maliciousness behind it. There is like, and this is what I would call specific coercion. There's real intent of her employer to exploit my client, and so my client had to hand wash her car every day. You know, just like way more degrading work than she was ever subjected to in Kenya.
Yeah,
you know,
sure.
where she had her community and her family, and she could still go home. You know, but all of a sudden in the U.S., while my client should have enjoyed freedom, somehow her employer really exercised freedom in a very corrupt way. And so the specific you know, tools of coercion that this employer used were also just, you know, threats of harm that would occur to my client if she didn't comply with the working condition, or if she were ever to refuse or try to escape. But then the structural part, the structurally coercive part, has to do with the immigration restrictions, because she arrived with a B1 tourist visa, and she's smart, and she figured out that that's not a pathway to green card. So then when her employer threatened her with deportation, my client knew that that could very well occur. You know, like she could very easily get deported, and that's what I would, that's what I characterize as structural coercion. Our immigration laws are not forgiving with respect to situations like this. I mean, there are opportunities to make out a case as someone who is trafficked, but it's a lengthy legal process, you know, and it's one that ultimately requires like a positive discretionary grant by the Department of Homeland Security.
And to kind of state the obvious, it's like employers understand the law, exploitative employers understand the law well enough, even if they're not experts in it, to kind of know how to coerce people into working under conditions that they would never probably agree to outright.
Yes. I think it's very clear to any employer that that hiring someone who's knowingly hiring someone who is undocumented, if one is going to do that, then an employer in good faith should do everything they can to create like the best working environment, and to not take advantage of that precarity in that person's life. And the undocumented status, I would consider, you know, part of the situational context that a worker may exist in that would you know, make them susceptible to being forced to work.
So in that same journal article that we're discussing, you also describe a fundamental tension in the different ways that the 13th Amendment is being applied in the U.S. I wonder if you'd lay out what that tension is and say a little bit about how you'd like to see that tension resolved.
Excuse me. So the the 13th Amendment, when it was enacted, it was the first Reconstruction Amendment. So it was the big one. Antebellum chattel slavery is over. Our Constitution prohibits involuntary servitude and chattel slavery and slavery of any kind, and the text of the amendment also empowered Congress under Section 2 of the amendment to legislate further to enforce the 13th Amendment in the future. And then in the interpretation of all that, and this is documented in the legislative history and also in Supreme Court opinions that adjudicated early 13th Amendment cases, that 13th Amendment was intended to not only eliminate slavery and involuntary servitude, but also all the vestiges, badges, and incidents of slavery. And
not to cut you off,
Sure.
but I think it's just worth saying for those members of our audience who don't have like a legal background, legislative intent is kind of a huge deal in the legal sphere because it's not just like, how can I interpret the letter of the law to mean what I want? If someone can make a strong argument that your interpretation is completely out of step with what the legislators meant when they put that language into the law, then that kind of cuts the legs out from under that argument.
That's right. Yeah, legislative intent would be the very first place that adjudicators will have to look to determine what the spirit of the law was. And even the strictest textual interpreters of the Constitution agree that legislative history, legislative intent, and when I say strictest interpreters, I'm thinking of are like the conservatives on the Supreme Court,
so-called originalists.
So-called originalists, yeah. And so legislative intent history is the first place to look, and they would agree, and so the 13th Amendment stood, not only for its plain language but also its intent, or as laid out in its legislative history, to eliminate the vestiges, badges, and incidents of slavery, and if taking sort of and engaging even more with that legislative history, then a researcher, student, scholar, whomever, lawyer, judge, would also agree that that meant future manifestations, and it also meant the consequences of the racial caste system that the consequences of the racial caste system that occurred because of slavery, because there's even more legislative activity to prove that point, because immediately after the 13th Amendment was enacted, Congress did use the 13th Amendment to enact the first Civil Rights Act, which is still, sound, good law, the Civil Rights Act of 1866. And this was even before the 14th Amendment was enacted, because Congress saw that, okay, the formerly enslaved people are now free, but in southern states and in cities, localities, whatnot, they are being prohibited from owning property, from engaging in private contracts, from suing people in court. So we're going to pass a Civil Rights Act immediately pursuant to the 13th Amendment as an effort to eliminate the badges and incidents of slavery. So, a full scope understanding of the 13th Amendment and its history revealed that it really was meant to be an anti-race subordination amendment. And so, interestingly, when we bring it to more recent years, when we bring the 13th Amendment and sort of its, and its legal doctrine, and how the legal doctrine around the 13th Amendment has evolved, the statute that is derived from the 13th Amendment that has undergone and continues to undergo the most activity and is most utilized is the Trafficking Victims Protection Act, and that is a federal law enacted by Congress in 2000 to finally define what human trafficking is, also known as forced labor. So to give forced labor a legal definition, and to also make unlawful psychological coercion as a means of inflicting forced labor on another person, and that's and so the Trafficking Victims Protection Act is a law that is actually written really well, and has the potential to reach a large scope of exploited workers. But this country in general has sort of a persistent problem with laws that might be good on the books, like our Reconstruction amendments, and how they're implemented. And the implementation is often is not advancing the promise of the law because of those who are implementing them. And so now if I like switch gears to the prison context, and so the 13th Amendment has a clause in it that prohibits involuntary servitude and or slavery except for punishment for a crime. And unlike the legislative history that is clear on the 13th Amendment having the intent to eliminate badges and incidents and future vestiges of slavery, there isn't any legislative history indicating that incarcerated people should always be subjected to forced labor. Historically, and again, this is Civil War times, individuals who were subject to criminalization and incarcerated were sentenced to hard labor, and that was something that was a common practice. But there's nothing indicating that lawmakers intended for the criminal system to be utilized in a manner to re-enslave those who had just been newly freed.
Right.
And in fact, after the 13th Amendment was enacted and southern states began to enact black codes, which criminalized newly freed slaves for really ridiculous lifestyle crimes like vagrancy, loitering. Those black codes were intended to threaten those individuals with criminal punishment or imprison them to then subject them to forced labor or convict leasing and that kind of thing. And there were a number of Supreme Court cases during Reconstruction that found those laws in Alabama and other southern states unconstitutional under the 13th Amendment, like very clearly unconstitutional.
Wow.
And so that except for punishment for a crime was not intended to be a loophole, but has been now in our modern day experience of mass incarceration and the rise of private prison industrial complex, that the existence of that clause in the 13th Amendment has been taken advantage of for prisons to force labor of those who are incarcerated and reap the profit and benefits from it.
Yeah, it's an insane history. I mean, wow. Well, I did mention at the top of the program when I was introducing you that you're part of this movement of scholars who's advancing this, I guess, theoretical framework called critical immigration theory. Would you mind breaking down exactly what that framework is? But before you even do that, I imagine some people who hear that phrase think about a more familiar phrase, but not necessarily such a well understood one, which is critical race theory. So if you don't mind starting with just the briefest possible description of what critical race theory is, and then going on to talk in some more depth about critical immigration theory.
Yeah, sure. So critical race theory is a theoretical perspective founded in legal academia by a group of legal scholars in the 70s and 80s. This group of legal scholars, which included folks like Derek Bell, Ian Haney Lopez, Richard Delgado, Kimberly Crenshaw, Angela Harris, they were influenced by critical legal studies, which was sort of which is another theoretical perspective on the law, and sort of had a longer existence. And I guess I mean, at the risk of, I don't want to oversimplify, because I don't want to do any injustice to the great, influential contributions of these folks that that are actually motivating me and my colleagues to, you know, to discuss critical immigration theory in a way that gives, you know, tribute to them. So critical legal studies, which, you know, I say like a precursor to critical race theory, was again, in a simplified way, it was encouraged folks to undertake a realist perspective on the law. So understand the relationship between law and society. So much that we study about the law, and so much of how it's rolled out appears to be divorced from social hierarchies. And
like blind to the existence of social hierarchies.
Yeah, blind to the existence of social hierarchies. Yeah, and so critical legal studies was an attempt to integrate our understanding of law with social reality. And so critical race theory embraced that concept and took it further, because critical race theorists recognize how fundamental racism has been, is, and continues to be in the structure of our laws, policies, and practices, and how practices are doled out. You know, it's just it's pervasive. Like race is so in this country in particular is such a kind of a bedrock of all of our laws, and there's also feminist jurisprudence came out of the same thinking, and also emerged during the same time as critical race theory. And so Kimberly Crenshaw is the person that coined the term intersectionality and really brought the two together. You know, so she brought critical race theory and feminist jurisprudence together. You know, and
I didn't know that emerged out of legal scholarship. Actually, that term, intersectionality.
Oh yeah. So she is the founder of that theory, and but also, you know, brilliantly. I mean, it's a brilliant concept, and so she also recognizes that that term is a really useful tool in lots of different areas, and you know, I mean, I use the term all the time. Everyone, you know, it's a really useful term, and she celebrates that. You know, when she invented the term, she was really her the work at the time was critiquing sort of second wave liberal white feminists who really essentialized the women's experience and wanted to prioritize gender inequality or sex inequality as the principal form of oppression that that all of us should be concerned about. And she so folks like Catherine McKinnon and Andrea Dworkin saw it as you know, unquestionable. You know, they could not, they were unmoving about it. You know, like any critique, any social critique has to foreground the oppression of women. And Kimberly Crenshaw said, no, that's not right, because your critique based on, you know, that foregrounds the oppression of women, you're only talking about white women. and it's a very different thing if we start to talk about intersectionality and how the law, for example, treats Black women in the workplace versus a gay white man or any other mix of identities. So in addition to, so she coined the term intersectionality, but there's a lot of resonance with this other concept known as anti-essentialism. So like in anti-essentialism embraces the idea that, I mean, we really are all unique. So individually we're all unique, and that has social meaning too. So then like, and then the conversation that I'm having with my colleagues now around critical immigration theory is actually a really exciting one. I think it's happening because while immigration scholars for a really long time, and the folks before me and my mentors have done the most profound work in educating everyone about how racism and immigration laws are inextricably connected. The conversation and this movement around what I refer to as critical immigration theory is happening with a lot of force right now. And I think because we're higher in numbers, like the first National Immigration Law Professors Conference in 1994 had like 10 people. And we just hosted the last one at Loyola, and it's during the pandemic and there were over 100 people, and so there are more of us, and also who an immigration law professor is different than who professors in other fields might be. There's a very close connection between being an immigration scholar and being an immigrants' rights advocate. Being an immigration scholar and a movement lawyer. There's a really close relationship between clinical work and doing on-the-ground work, and also theorizing and writing about it, engaging in a broader conversation about it. So, so me and my colleagues are identifying something that is happening now, and we want to recognize it to empower ourselves and each other. Because critical race theory is absolutely legitimate. It's we want to embrace it in our field, as other fields have done. Tax, employment, there are other analogs to this. So in embracing it, it encourages our own conversation on ideas, and it also pushes back against the conservative attack, and which is all like based on lies about what critical race theory is.
Right, right. Which is part of the reason that I wanted to start that question by having you lay that groundwork, because, yeah, there's just so much misinformation circulating about that term. So yeah. Mm-hmm. Yeah, thank you so much for that answer. I really want to, I guess, take things a little bit more into the concrete now.
Sure.
And, I think that if you just talk to a lot of different people, you'll encounter a lot of people who see it as basic common sense that U.S. citizens should enjoy some rights that non-citizens don't enjoy. I'm curious how you sort of what your take is on that viewpoint, and if you do disagree, to the extent that you disagree, would you explain why and talk about maybe what a different approach would look like? Mm-hmm. What would be the benefits of offering non-citizens the same sets of rights that citizens enjoy, or if not all the same rights, at least substantially many of them?
Mm-hmm. Yeah, sure. I think that immigration is or as a legal topic is really complicated, because our immigration laws dole out different categories of immigration status to non-citizens, and with each of those categories, non-citizens have different rights or privileges and disadvantages too, and it's those different categories create sort of a hierarchy among non-citizens, and then so the temporary visa holder versus the permanent visa holder, and then the undocumented population that has resided in the United States for a really long time and survived undocumented and have proven to have contributed a lot of equity and value to our economy and our culture, et cetera. And then there are those migrants that may not have facially eligible, or they may not have like prima facie eligibility to enter the country, but should be able to enter because of humanitarian concerns. And then and people can have different opinions about each category of those, those subpopulations. And so where most of my work has been focused on the undocumented population that resides here, and that's where I think it's simply inhumane, and I mean, from lots of different, it's inhumane, like it's impractical, it's illogical, just all of these, to not provide a pathway to citizenship. Or, I mean, if I could run DHS, or sorry, if I was a lawmaker that could, if I could push a legalization plan through, I'd want to make it as expedient as possible. And I'm very happy to engage in debates about our long-time residing undocumented population. It just, to me, makes no sense for people we know to be undocumented, after living here for at least 10 years and feeling like there's no other home for them but here. They have integrated into our communities, and the only barrier to their full integration is our immigration exclusions, and then also the reality that as more time passes without a legalization plan for the existing undocumented population, the more and more mixed status families there are, and so everyone, not everyone, but so a lot of people in LA have members of their family who are undocumented, right. and that causes a lot of personal fractures for that, instability and personal fracturing for that family and that community, but also just from, again, like the pragmatic, even from a law and economics perspective, like how government should be run, it's totally inefficient, and it really stymies the progress of individuals who could be and are the biggest contributors to our society and economy. So that's where I focus.
Yeah. I want to ask you a follow-up question, and I guess about the 6 minutes that we have left in this interview. I was recently reading a piece that basically argued that this slogan or phrase, "no human being is illegal," rings somewhat hollow in a legal environment where people indeed are inherently criminalized if they're undocumented. Can you talk, I mean, you sort of got at it a little bit, but I wonder if you could go into more depth about the effects on non-citizens of this criminalization, but also, if this isn't too much of an answer to fit into a short time, Do you see citizens also being negatively affected by this form of kind of automatic or almost like mechanical criminalization? Because I was reading another forthcoming piece of yours, and you mentioned this case, Hoffman Plastic Compounds Inc. versus the National Labor Relations Board from 2002, in which, and this is what you wrote about the case, the court, meaning I think the Supreme Court, held that an undocumented worker who suffered illegal retaliation by his employer for exercising his labor rights could not recover full labor remedies because his employment violated federal immigration law. So, I mean, with that holding in place, couldn't that lead to an outcome where there's an overall trend of depressing wages across the board, including, for example, for citizen workers?
Yes, yeah, and that's definitely one of the chief critiques of the Hoffman ruling, that by depriving an undocumented worker of his full labor rights, that's a deprivation for all workers. And similar reasoning has sustained protections under other employment laws, like the Fair Labor Standards Act. There have been other court rulings that have stated that undocumented workers, just like citizen workers or authorized workers, are entitled to the full protection of the Fair Labor Standards Act. So it's really weird, I mean, I guess, you know, not very
contradictory or something.
Yeah. The Supreme Court's ruling, you know, like in that case, Supreme Court prioritized immigration enforcement, and namely immigration enforcement in the workplace, and that's something I'm very opposed to, and over labor organizing rights without any justification. You know, just made that decision that immigration enforcement should be prioritized, you know, over labor rights. And I guess the other thing I'll say is that the illegality of associated with unlawful presence is, I think it's problematic more as a rhetorical device than anything else, because that affects citizens who immigrated or who are of color or whatever, you know, like that kind of illegality that is that Black persons are marked by. Same kind of illegality that brown people are marked by, you know, and to some degree it's a conflation with anti-immigrant rhetoric about undocumented individuals.
Well, Kathleen Kim, this has been an absolutely amazing conversation. I feel like I've learned so much in a very short amount of time. I hope that our listeners get as much out of it as I did. And yeah, thank you for making yourself available and sharing some of your thoughts and your work with us today.
Thank you. Thanks very much, Adam.